Good afternoon. My name is Shane Starkey, and I would like to welcome you to today's Thompson Hine sponsored webinar. I am joined by Nathan Holmes, who will be assisting with the presentation and monitoring your questions. Today, we will cover aspects related to executive compensation. This webinar is the second in a series of webinars slated every Thursday at noon for the next 4 weeks. Each webinar will explore a different benefit-related topic. Please join us every week or just for the topics of interest to you. You can register for additional seminars through the invitation you received. You can also apply for CLE or HRCI credit for today's webinar. There is an attorney affirmation form in the handout section, and we'll give you the code you need to complete that form at the end of the webinar. During the webinar, please feel free to use the question panel to submit questions. We will answer questions at the end of the webinar as time allows. Any questions we do not answer during our time together today will be responded to via email after the webinar. And with that, we will start, and I will turn it over to Nathan Holmes.
Thanks, Shane. The next slide shows our agenda that we just moved past for our meeting today. The topics we're going to cover this afternoon. The hedging policy disclosure rules recently came out from the SEC, a discussion of non-employee director compensation matters, the impact of the 2017 changes to Section 162M of the Internal Revenue Code, and we'll also touch on CEO pay ratio disclosures, potential new disclosures related to human capital management, and time permitting, some other proxy season considerations. So our first topic is hedging policy disclosures, and these rules actually relate back to the Dodd-Frank Wall Street Reform and Consumer Protection Act of, I think that was 2010, Shane.
It was
2010.
Long time ago.
Yeah, so long time, and here we finally are with rules about hedging policy disclosures. And funnily enough, there's still a couple of outstanding rulemakings for Dodd-Frank that have yet to be finalized, dealing with clawback policies. There's one other, if I'm not mistaken.
The pay for performance.
The pay for performance disclosures. Who knows whether we'll ever see those? But we do have now rules on hedging policy disclosures under item 407I of Regulation SK. U.S. public companies now have to disclose what their policies are, whether they permit their employees and directors to hedge the value of the company's securities. The effective date for these rules is really July 1, 2019, and the way the effective date is drafted, it's not for fiscal years that begin on or after July 21, 19. It's really for elections of directors that occur after July 1, 2019. So, for example, if you're a June 30 fiscal year company, your proxy statement that you'll be filing, any day now is going to need to address this topic.
That's right, and the SEC had just kind of a strange way of writing that effective date. It's different than how they usually write it. So if you are a fiscal year company, you want to take a little closer look at that effective date.
Mm-hmm. That's right. And that's for most companies. If you're a smaller reporting company or an emerging growth company, you have another year until July 1, 2020 before you will have to comply with these rules. So what this hedging policy disclosure rule requires is a disclosure of any policies that the company has adopted regarding the ability of employees and directors to hedge, that is to purchase financial instruments or otherwise engage in transactions that hedge or offset or are designed to hedge or offset any decrease in the market value of the company's stock, company equity securities. And those could be shares that are delivered to employees as payout of compensation awards, or just shares that they purchase on the open market. The rule does not require that the company have a policy or that its policies say anything in particular, but it does require that you to make a disclosure: do we have a policy or not that applies to our employees and to our directors, and if so, what does it say? The disclosure here could be either a summary of the company's policy, describing who's covered, what category, if there are specific categories of transactions that are allowed or disallowed, saying what those are, or just disclosing the policy, including the policy itself in the proxy statement. Now, many companies already have policies that prohibit hedging, pledging of securities, and for most public companies, there already is a disclosure related to this point in the compensation discussion and analysis section of the CD&A. The CD&A requires a description of all the material elements of a company's compensation program, and for many years now, the rules have said, a material element of your compensation program for your named executive officers may be whether you permit NEOs to hedge or their stock. And so typically your CD&A will already say, we don't, if you have such a policy, we don't allow our NEOs to hedge company stock. The new rule, however, is broader. It requires a disclosure with respect to policies that apply to any employees and to directors, right? So, the disclosures are going to be the disclosure that's required is going to be perhaps somewhat different from the existing language that's already there in the CD&A, and this is really the time where, especially calendar year companies are thinking about going to the compensation committee and letting them know about this new disclosure rule change and thinking about, are there any changes we should make to our policies or what are the changes going to look like in terms of how we disclose this? And when you're thinking about what are the kind of topics that you might address with respect to your existing hedging policy and what you're going to do to address these new rules, the one topic is, who's going to be covered? Who's covered by the hedging policy that the company adopts? I think we find in practice for many companies, employees and directors are already covered pursuant to an insider trading policy. Doesn't have to be the case, but it might be the case that you already have a policy that applies to everyone that prohibits some sort of hedging or pledging.
And I am seeing a lot of companies apply that policy if they're adopting it or revising it and having it apply to all employees and directors, all employees worldwide as an example. And it's just making sure that you have a process in place for appropriate training and appropriate certifications that people are complying with the policy so that you can tie it back if questioned in your disclosure about how you're enforcing the policy. A couple companies have a more limited scope so far, and I don't have a larger sample size to really know what the trend is, but it just kind of depends on just thinking through the issues of compliance and training and education about it.
Mm-hmm. Yeah, again, the rule is not prescriptive, doesn't tell you what you have to do, so your policy can be what it is, and there's a variety of alternatives that you might consider. Is it all employees, or is it just people who get equity awards? Is it executive officers only? All sorts of options that could be there. Again, may already be covered in your insider trading policy. And we haven't heard yet from ISS or Glass Lewis, the proxy advisory firms, to see do they have any preference about what these policies might say. We know they like them in general, but they haven't had occasion to really get into the weeds on what a hedging policy ought to say from their view of what best practices might be. So that'll be interesting to see as we get some more disclosures here, whether they will update their voting guidelines to address that point. Another design decision when you're thinking about your hedging policy and how it should apply is, well, what does hedging mean? How granular should we get in defining hedging, or should we define it at all? The SEC rule really doesn't define hedging either. I mean, you're really talking about something that gives downside protection is the concept, right, to an employee with respect to the value of their company stock. I think often when you see this in insider trading policies, I don't think I've seen many detailed definitions of exactly what's in and what is out. So one approach might be, not really to define hedging, to leave it more open-ended and put people on notice that transactions that, offer downside protection against their securities are something that, the company is not going to permit.
So if I work at a utility company and I invest in a utility index fund, is that hedging? I mean, that's the problem you get into
Right.
is, if you let a lawyer, start asking questions about what hedging means, you can come up with all kinds of different scenarios where you could say that could technically be hedging, or I invest in an industry that is countercyclical to my company. So, you can get into, gosh, maybe it shouldn't apply to those situations, but most companies that we've worked with so far have said, let's just leave it vague and, or not vague, just say hedging. And then if people have questions, they can come ask us and we can decide at that time.
Certainly you could carve a variety of transactions out or explicitly into what is hedging, and things like those kind of broad-based portfolio diversification transactions might be something where you think about, do we make it clear to people that they don't have to worry about that as something that the policy covers? Another consideration in terms of complying with these new rules, this goes not to the policy itself, but to the disclosure, is where and how do we make this disclosure? As we mentioned, there are, for most companies already, anti-hedging policy disclosures in the CD&A with respect to named executive officers. And so you sort of got that piece that's already in the proxy statement that you need to kind of reconcile with this new rule. And the SEC's rules say, you got a couple of basic approaches here. One is you include the new hedging policy disclosure that describes your policy with respect to all employees and directors somewhere outside of the CD&A, and then you keep the separate disclosure in the CD&A that's specific to how that policy applies to your named executive officers. That's one approach. Or alternatively, you could incorporate the new disclosure into the CD&A itself. So just have the CD&A address not just your named executive officers, but also all of your employees and your directors. You could do that directly in the CD&A, or it could be by an incorporation by reference into the CD&A from a disclosure that's included somewhere else in the related party transaction section of the proxy statement, for example. And it'll be interesting to see where this goes with what companies are deciding to do. And I think that could vary depending on things like how detailed is your policy and how are you going to disclose it. Is it just a paragraph or a couple sentences in your insider trading policy that you're really just describing in the proxy statement, or is it did you decide to take the approach of really getting into the weeds on how hedging is defined, what transactions are in or out, who's covered, and if so, is that something where you want to include the whole policy somewhere in the proxy statement? So I think that could affect it. Technically, I think one consequence, if you include either include or incorporate this disclosure into the CD&A, that technically makes this disclosure a part of the say on pay vote, since it's part of the disclosure related to compensation in the proxy statement. I don't see that as a huge reason to do one or the other, and I suspect that we'll probably see a lot of situations where the policy is described outside the CD&A but might be incorporated by reference into the CD&A.
Yeah, I agree on that.
With that, Shane, would you like to talk a bit about non-employee director compensation? That's
yes.
We've had a lot of
developments here. So who here on the webinar sets your own compensation? I can't see a show of hands, I know, but I don't set my own compensation. I'm sure most of you don't set your own compensation, but non-employee directors of public companies under state law get to set their own compensation. And so you can imagine that these arrangements are sometimes ripe for shareholder lawsuits on alleged excessive director compensation. And that's because generally when directors make decisions on behalf of the business, they are protected by the deferential business judgment rule. And that's where courts give broad deference to directors when making business decisions that they're typically not going to second guess. However, if there is a conflict of interest or a self-interested transaction that directors are engaged in, and certainly setting your own compensation would be one of those, then there's a different standard that applies to reviewing those decisions, and that's the entire fairness test. And that shifts the burden of proof to the directors if challenged on setting their own compensation, that they have to prove that the transaction was fair to the company. So it's a higher hurdle for the directors. It's not the nice protection that you typically have on director decisions.
And this gets procedural too, right? If you're a plaintiff's lawyer who's out there rounding up shareholders to sue the company, that shift of the burden to the company just means you can take your case farther down the line, and it has more value to you to try to get a settlement.
Push for settlement. That's right. There were a series of cases. One was noted here, Seinfeld v. Slager, where the decision reviewed a plan that had a meaningful limit on director compensation that was approved by shareholders. So, as an example, you could say in your equity plan that non-employee directors can't receive compensation, whether in cash or equity, in any 1 year in excess of $300,000. And then that plan was approved by shareholders. And there's the line of cases that said, if you have shareholder ratification of a meaningful limit on director compensation, and if it's $350,000 and you pay each director $300,000, well, shareholders ratified that transaction, and so we're going to kick you back into the business judgment rule. So it's like that shareholder ratification defense. And as a result, many companies, when they're putting in their equity plans, which are approved by shareholders, would put in a limit on director compensation, typically both cash and equity, and it'd be, $350,000 per director, $400,000 per director. I mean, something in that range, with the thought being, well, we'll get shareholders to approve that limit, and then we won't have to worry about these shareholder suits. Or if they come in, we'd have the protection of the business judgment rule to kick that suit out, and on a motion to dismiss.
And there were several years where that was really the approach that companies were taking, Shane,
Yep.
right? And what I tended to see first was kind of starting with just a limit on the equity awards, right? That, so here's a limit on the equity that can be granted under the plan. It is an equity compensation plan after all. And then people started saying, well, let's make sure we cover the cash retainer as well, just to, try to discourage some plaintiff coming in and making a frivolous lawsuit against the company. We've got this limit, shareholders are going to approve it. These are going to be meaningful limits. We're going to think about what that number is. They aren't the limits like, that used to be included in equity plans for purposes of, for tax purposes under Section 162M, where you were just trying to include, you had to do something in the plan. It's a high limit that you never ever thought would be paid. But people gave some thought to what's the right, what's a reasonable limit to set on director comp, and we thought we were in a good place until the end of 2017. Right?
Yeah, that's right. So most equity plans had some sort of limit in there that was approved by shareholders, and everyone thought they were safe going forward with the business judgment rule. But then Investors Bancorp came out, and in that case, one could look at it and say maybe these were bad facts that created bad law, but the plan did have a limit on director compensation, and that limit was approved by shareholders. But the limit was the number of shares that could be granted, the maximum number of shares that could be granted to all directors, not on an individual basis, but all directors, and over the life of the plan. And typically we would have our limit apply to each director during any one calendar year to 30% of the overall share reserve. And so it was something a lot different than what you would typically see in an equity plan, common practice. But anyway, there was a limit at least. And so the company tried to argue that they had the shareholder ratification defense, and the court kind of took a turn here, and instead of really analyzing whether that 30% was a meaningful limit, the court said, really, if you have discretion to grant awards, you're going to have a hard time getting the protection of the business judgment rule, even if you have shareholder approval. And the court really said, it looks like the business judgment rule is only going to apply to two situations where either the stockholders have approved the specific awards to the directors, which you typically don't have stockholders approve annual director grants, as an example, or the plan is a non-discretionary formula plan. As an example, the plan would say each year, each non-employee director will receive a grant of stock options covering 60,000 shares, and the shareholders approve that. So cutting away like this overall limit that we would use and really limiting the situations where you can use this shareholder ratification defense on director lawsuits. And then that concept was again, whoops, sorry, Nathan, sorry. got ahead of you there. That concept was affirmed in Stein v. Blankfein, where this was the Goldman Sachs board of directors, and a plaintiff came in and alleged that those directors made nearly twice as much as their counterparts. So they were saying, look, you're paying these guys twice as much as their peers, and it's corporate waste, it's excessive compensation. Goldman kind of pushed back and said, well, the shareholders approved our equity plan, but the problem was there was no specific limit on non-employee director compensation. And as a result, the directors had a lot of discretion on making grants, and the court really came in and said, look, if you have discretion to make grants, then even if the stockholders approve of the plan, they didn't really know what they were approving. They're not really ratifying anything, any specific grants, and so therefore we're not going to have the business judgment rule to apply here. We're not going to grant your motion to dismiss. The plaintiffs can continue to pursue this case, and so not the result you want, certainly. And so it looks like the trend of having that specific limit, no non-employee director can get awards greater than $350,000 per year, as an example. Still probably a best practice, but it's probably not going to give us the legal protection that we thought it was going to, and as a result of these line of cases. Certainly, shareholder lawsuits are one thing to worry about with director compensation, but ISS, the proxy advisory firm, is in the game of reviewing non-employee director compensation as well. And starting with meetings after January 31st of 2020, ISS reserves the right to issue adverse vote recommendations for directors when there is a recurring pattern of excessive pay without any kind of compelling rationale. And you'll see in this slide, we kind of define what ISS means by excessive pay, but, you kind of have to be somewhat of an outlier within some sort of defined peer group monitored by ISS. And ISS recognizes that non-executive chairs and lead independent directors probably need to be benchmarked separately than your typical board member, because a lot of times those positions do demand higher retainers and fees for the additional duties. If you're an outlier, if you do have a high director comp arrangement, there can be a compelling rationale, and ISS recognizes there might be one-time onboarding grants for new directors that could justify the excessive, or the outlying status. Special compensation related to a corporate transaction or special circumstances where you have like a special committee, or if a director has a certain specialized skill like a scientific expertise for a biotech or something of that nature. So that kind of is what it is, a little bit formulaic, but then there's also a qualitative review as well. What we're seeing and what we're recommending with clients over the last several years is that we're really beefing up the description of director compensation in the proxy statements. We're making it look more like a CD&A type disclosure, certainly not as long, but providing a lot of detail on how often director compensation is reviewed, how it's reviewed, how the consultant is involved, justifying each element of pay. If there is a change, justifying why there is a change, and then picking up, the little things like, do we have stock ownership requirements? Are there holding requirements? What are those types of best practices that we've adopted and we want to promote? And certainly, the old line problematic practices like performance-based equity for directors, retirement benefits, perks for directors, those things are always going to raise a flag, and so we try to stay away from those if we can.
Yeah, and ISS has noted that they think including a meaningful limit is a positive feature, right, in the plan, as you would expect.
Right.
So I think if you've got that kind of limit in your plan, you're keeping it. If you've never got around to including that, do you add it now, given that it has less effect under state law for discouraging shareholder lawsuits? Perhaps not, but certainly director comp is more under the microscope these days than it used to be, and bears looking at things like what your limits are if you have them, and how you're disclosing the compensation of your directors. The next item on our agenda for today is to talk a little bit or revisit the changes to Section 162M of the tax code, which was the $1 million corporate tax deduction limit, where companies can deduct only up to $1 million worth of compensation paid in any year to their covered employees. And as we all know by now, there were really significant changes in the 2017 Tax Cuts and Jobs Act that repealed the old performance-based compensation exception that had existed for many years and expanded the definition of those covered employees who's subject to Section 162M. So those changes came in at the end of 2017, effective sort of starting 1/1/2018, and companies have been living with this for a little while now. And 162M is kind of in some ways receding into the distance, right? The old law is gone, except with respect to arrangements that are grandfathered in. It's sort of going away, and now how do we live with 162M going forward, where it's much more of a harder cap on compensation deduction by the companies. So where we are these days, when we think about the $1 million rule, one of the key things to do is to make sure you're appropriately tracking your covered employees. And as a result of the law changes, it's less of a year to year, 1 year. Each year doesn't stand alone. It's a cumulative list. So you really look and see who is on the list for, if you're a calendar year company, for your 2017 year. They were on the list under the old law. They were a covered employee. They're always going to be a covered employee as long as they're receiving compensation from the company. Then it's also going to be anyone who serves as the CEO or CFO at any time during the year, and the folks who are among the 3 most highly compensated executive officers other than CEOs or CFOs, whether or not they're serving at the end of the year, which again was an old law rule. And regardless of whether they actually get disclosed in the summary compensation table, you can have some very peculiar scenarios where you might have someone who's a covered employee who's not in the summary compensation table. And again, that list is going to grow over time, right? Whenever someone comes into the list, sometimes you'll have situations where executives make it into the covered employee list, and their compensation has to be disclosed in the summary comp table for a year, and then they drop out, right? Well, even if they drop out of the table, they're still a covered employee, and their compensation is still going to be subject to that $1 million annual deduction limit. So keeping track of who are the covered employees, that's a key item going forward in all cases. Another thing to pay attention to is grandfathered amounts. The changes under the Tax Cuts and Jobs Act to Section 162M, that is principally the repeal of the performance-based compensation exception and the expansion of the covered employee definition to pick up things like the CFO. Those changes do not apply to remuneration payable under a written binding contract that was in effect on November 2nd, 2017, which was the date that the bill was introduced, as long as that written binding contract isn't materially modified at any time after that date. You're looking to applicable law as to, under the IRS's view of the world. What's a written binding contract? Well, if some applicable law, like state contract law, for example, requires a payment if the conditions under the contract are met, then that's a written binding contract. On the other hand, a contract that the company has the unilateral ability to cancel or renew, terminate, is only going to be treated as terminated at the earliest possible date, right? So if you have a initial contract term that ends, at the end of 2019, and you have the option to renew, if it was still grandfathered till the end of 2019, that'll be the latest date that compensation paid under that arrangement would be grandfathered under the old rules.
And these are really 2 things: the tracking of the covered employees and the tracking of the grandfathered amounts. It's communication between the HR department and the tax group, because the tax group needs this information. They probably already have the list of the covered employees, but it's going to grow over time. Tax group may be tracking that, but they may need help from HR to make sure they have that list right. And then also the tax group is going to have, it's quantified the grandfathered amounts. There could be amounts under deferred comp plans and such that are grandfathered, and tracking those amounts, tracking earnings if applicable, and just making sure there's proper communication between the HR group and tax group so that the tax group can do the tax return properly.
Mm-hmm, mm-hmm. Another thing to keep in mind, so if as Shane said, the tax group's going to have thought through, what's grandfathered, but you've also got to bear in mind that if you materially modify those arrangements, they can lose their grandfathered status, right? So if someone's, from the legal or HR department is thinking about making changes to a compensation plan that might have grandfathered amounts, let's, take a step back and make sure that we're not doing something that would lose the company a tax benefit that we otherwise, would be able to keep if we can do it, right? So material modifications for this purpose really all go to at some level increasing the amount of compensation. So that's what the SEC guidance says. A material modification occurs when the contract is amended to increase the amount of compensation payable other than just a reasonable cost of living adjustment. There's some limitations here, and that could be a modification that happens where there's an acceleration without a discount for time value of money. But it really goes to amounts. So there's lots of amendments that you could make to an arrangement that's grandfathered that retain its grandfathered status, but anything that could potentially end up changing the amount that's paid is something that could be a material modification that loses the grandfathered status.
And so it's really, one more item on your checklist. Whenever you're looking at making amendments to your executive compensation plans, you're always thinking about who needs to approve the amendment. Do we need participant consents? Do we need to disclose this change in a Form 8K? And now another line item on your checklist is, we need to talk to tax and make sure we're not materially modifying something that was grandfathered under 162M.
Mm-hmm.
So just another issue to spot when making changes to exec comp plans.
Mm-hmm, mm-hmm. And those changes kind of look back to prior awards, what's grandfathered. When we're thinking about what other effects do these 162M law, Section 162M changes have going forward, well, you could think about some potential plan design changes, right? For example, just deferring compensation until the time that after the time that a covered employee terminates employment, that by itself doesn't eliminate the 162M issue. But if you defer compensation and spread the payments out in installments such that, compensation is below $1 million in each year, or you limit the excess over $1 million, that could help save money for the company. That's something you could think about. We certainly haven't seen any sort of wholesale move away from performance-based compensation. You could think about, do we pay more fixed compensation and less that's tied to performance goals because we don't get that tax benefit? But shareholders and shareholder institutional investor advisory firms definitely want to see performance-based pay be a big part of the executive compensation for public companies. So we're not seeing a lot of changes there. One thing that can be somewhat helpful here is you actually have a little bit more flexibility to deal with adjustments to awards where situations come up that weren't contemplated at the time that the award pays out. Under the old law, if you wanted to protect that tax deduction, you could have negative discretion to make adjustments to performance-based awards that would reduce the payout. But if you use discretion in a way that caused an increase in the payout above the amounts that would be earned based on the tax law goals, you'd have a problem. Under these rules, it doesn't really matter anymore for new awards. The $1 million rule just applies one way or the other. So you could potentially have adjustments that increase payouts. You wouldn't have a tax cost of that, but you might have an accounting impact, and certainly you'd have a disclosure issues to think through if you're making any adjustments to awards that would increase payouts above what someone would have earned based on the terms of the award. Another thing that you could think about is an inducement award. And this is a type of equity award that both the New York Stock Exchange and the NASDAQ rules allow in certain limited cases equity awards to be granted as inducements to new employees outside of the shareholder approved equity compensation plan. Ordinarily, the stock exchange rules are going to require that shareholders approve your compensation plan, but in appropriate cases, you could use this inducement approach to help extend the life of your share plan reserve by granting an award outside of the plan to a new hire. So the basic requirements here, these awards, and again, you can do this now. You could have done it before. If you'd done it under the old tax law rules, these awards would not be deductible, would not have been deductible under the old law rules because as a condition of the performance-based compensation, you needed a shareholder approved plan. Under the new law, they're not going to be deductible to the extent it's over $1 million anyway. So there's no sort of tax law disincentive to using the inducement award approach when you've got a scenario where it's for a new employee, for a rehire after there's been a bona fide period of non-employment. It's got to be a material inducement to the acceptance of the employment. So you're going to want to have, an offer to the employee that says, this is a part of the offer that we're making to you, subject to approval by the comp committee or majority of the independent directors.
And that's an important one. You can't do it after the fact.
Right.
You can't say, okay, we hired the person. Hey, let's make this upcoming grant an inducement award. You really have to have some sort of paper trail to show that the equity award was offered to this person prior to being hired and that it did induce them to accept employment.
Mm-hmm, mm-hmm. And it does have to be approved by your comp committee or a majority of your independent directors. You need a press release if you're going to do this type of award that describes the material terms of the awards, and you have to provide notice to the stock exchange. And while you don't need, if you meet these requirements, you don't need shareholder approval of the plan, you're still issuing shares to an employee, so you need to either have this be pursuant to an effective registration statement or have some sort of exception from registrations. So ordinarily this is going to involve also filing an S8.
And it doesn't seem that the inducement awards are a big red flag for ISS or Glass Lewis. I mean, certainly they could be abused, I'm sure, but if you're just using them in the ordinary course to bring on new talent, it seems to be okay in their eyes. Now, certainly you do need to disclose in the proxy statement the number of shares that you've granted under shareholder approved plans and the number of shares that you've granted outside of shareholder approved plans. So it will show up in the proxy statement, and certainly it's going to factor, it's like any equity award, it's going to get factored into your burn rate and your dilution when you go back to ISS and Glass Lewis. When you're looking for additional shares on your equity plan, it's going to factor into that analysis, but there doesn't seem to be any big red flag so far from the proxy advisory firms on these inducement awards.
Right. They won't ignore it. They'll take it into account when they're, reviewing your next equity plan proposal, and it's just, part of the shares that you've already issued, right? But Shane, our next topic.
Yeah, so flipping forward, CEO pay ratio disclosures. So this was another Dodd-Frank rule that was implemented 8 years after the enactment of Dodd-Frank in 2018, or first became effective. And this is what I think most people consider to be really useless information, but public companies are required to show the ratio between their CEO pay and their median worker pay. And, I guess from my perspective, we always knew what the CEO made. We know that CEOs make a lot more, but now we have a new piece of information, which is median employee pay and the ratio of those two amounts. No one seems to think that this is particularly relevant information for investors. The media has written articles about it, and at one point we were worried about employees, looking at the median pay, and it's half or above, half or below. So someone's going to get upset when they look at the median number, thinking that they're below median. They could look at the median pay of their peer companies or competitors, and get upset and want to change jobs and all these things. But really, it's been a non-issue. No one's gotten too worked up about this, and it's just something we have to administratively go through each year and do the calculation. So we've gone through it for 2 years now. Most companies are just doing kind of a minimal disclosure on this, just the bare basics of what needs to be disclosed. It's usually disclosed outside of the CDNA, kind of at the end of the compensation tables, and people just move forward. Now, there was a push in 2019 where the S&P 500 companies received a letter from a group of institutional investors where the investors were saying, would you please consider disclosing additional information in your CEO pay ratio disclosures so that we can have a better sense of your pay practices. And that letter listed out a number of different things that these investors would like to see to provide supplemental information or additional context within which to put that CEO pay ratio. and I have those listed there in the PowerPoint, but, things such as, breaking down your full-time versus part-time employees, how you use temporary or seasonal workers, what's the tenure and the experience of your workforce, educational level, skill set, what's your overall compensation philosophy? You told us about your named executive officers, your top 5 people, but what is your overall comp philosophy? What's your overall compensation mix for employees? I mean, interesting questions, but certainly none of these are required to be disclosed to the public. And, our experience was most companies did not take these investors up on their offer. But there were some companies that did. Some companies are starting to provide more context, more information on their management of their human capital at their companies. So the next slide is saying, are we going to see something different in 2020? And I think we will, and that's because a couple things have happened. So human capital management, it's probably the next disclosure trend. So at a very high level, we're talking about disclosure that provides information about a company's human capital and viewing it as an important asset. There is a growing recognition of the business impact of effective human capital management. And there's a view out there that those who get human capital management right, I mean, those that manage their employee base properly, are going to produce a higher value for shareholders. Currently, all we have to do is disclose information about named executive officers, again, typically your top 5 paid people. We have to show a CEO pay ratio, and we have to show the total number of employees. And that's about all you get. So investors have been pushing for more. So as an example, since 2015, and you probably read about some of this in the press, but Arjuna Capital and certain other funds have been submitting gender pay equity proposals to various public companies. And it's kind of been industry specific for now, but the proposals are expanding, and these groups are looking for stats on gender pay equity, what's the ratio of male to female worker, various different slices of that, and analysis, but some companies are voluntarily disclosing it, some are doing it pursuant to these proposals. Arjuna Capital recently issued a report card on various companies, grading them on their gender pay equity stats, and a lot of companies got failing grades under Arjuna Capital's view. In 2017, there was a coalition that petitioned the SEC for rulemaking to require human capital management disclosures. And recently in March, there was another subcommittee of the SEC on human capital management issued recommendations to the SEC asking the SEC to adopt rules that would help investors understand the human capital at a company and how it's being incentivized and managed. And with all that, the SEC kind of listened, and recently, August 8th, came out with a number of rules, a number of amendments to existing rules under Regulation SK, but one of them related to human capital management. And so the SEC is looking to replace the current requirement to simply just disclose the number of employees with a requirement to describe the company's human capital resources management. And it's a principles-based disclosure. The SEC recognizes that different industries are going to have different factors that they need to focus on and disclose. So the SEC wasn't going to be really rigid with how, with the types of information that it wants, but it certainly did give examples, and really kind of focused on the metrics that the management uses and the objectives management uses when managing its business and its human capital resources. Examples would be stats relating to the attraction, development, and retention of the workforce. Certainly other aspects that I've seen disclosed voluntarily are, safety of the workforce, safety initiatives, turnover, how stable is the workforce, what's your turnover look like, training, what companies do for training and workforce advancement, certainly diversity statistics, that you're seeing more with the gender pay equity proposals, and similar matters, employee satisfaction. These are all just kind of additional things that we've seen out there that companies are starting to think about. So the upshot of all this is we don't have to do anything yet, but certainly there's a lot of pressure from investors and now the SEC to focus more on this. And companies are asking us, well, what do we do? And one thing we're seeing companies consider is trying to get ahead of all this. And one way to do that is to put direct board oversight on human capital matters. So that function seems to fit squarely within the compensation committee. And so companies are considering whether they want to amend their compensation committee charters to specifically address the board's oversight of human capital management, thinking through what role the chief human resources officer is going to play in all this, and whether it's direct reporting to the comp committee or some other arrangement. But the CHRO certainly is going to play an important role in this developing trend. And then also, do companies want to start voluntarily disclosing some of this information, whether in the 10K or the proxy statement, to start to get ahead of the curve on this and really kind of tout, if it has a great story to tell, telling that story about how it's managing its employees and how that's directly related to the business and creating shareholder value.
Shane, it seems that this is really sort of just getting started in some ways. We have this SEC disclosure rule it's in proposed form right now, right? There's a proposal out there for comments, and it's sort of starting with just a suggestion that you come up with a good way to describe human capital management in your registration statement. Nothing required for the proxy statement yet, but I just suspect we haven't seen the end of this. We're really in the early stages of how companies address who has responsibility and what are we going to say about it, how to be, as you say, proactive and tell a good story if there's one to be, hopefully there's one to be told.
Right. So I think before we do questions, maybe we can burn down through a couple just general items here on other proxy season considerations, and then we'll talk about some questions.
Sure. So as proxy season's coming up, some of the topics that have been hot topics in the last few years and are likely to continue, or new items for this year. Stockholder engagement continues to be an important topic and an area where I see more disclosure from companies than in prior years. I mean, it's particularly important if you have a situation where you've got a relatively low say on pay vote in a given year, if there's something that shareholders perceive to be not so friendly about your compensation policies, that you reach out to them and you talk about, here's what we did in terms of outreach to our shareholders, here's what we heard, and here's what we did in response to what we heard. But even outside that, I think more and more companies are making it a regular part, making the executive compensation be a part of their regular stockholder engagement process and describing that in the proxy statement clearly.
Absolutely, and that arises out of the Dodd-Frank Act, and probably the most impactful compensation rule under the Dodd-Frank Act was that say on pay, where shareholders get to vote on a non-advisory basis on the pay to the top executives of a company. And even though it's a non-binding vote, you don't want to fail your say on pay because it just results in a lot of bad consequences. And so that, as a result, the trend has been, and it continues to be, that companies are engaging stockholders much more on their compensation programs, soliciting input, and actually changing programs based on that input. So, you can look at it and say that's a really good development. I know we've been a little bit hard on Dodd-Frank here during this discussion, but this is something that I think is probably healthy to really enforce and encourage that dialogue with stockholders.
Absolutely. Another topic in the last few years, there have been some SEC enforcement actions related to perquisite disclosures, and that can be one of those areas that, maybe because we're talking about small dollar amounts or one-off arrangements, in some cases, maybe it might have the possibility to fall through the cracks. I think it's just important to, as you go into proxy season, to be doing the diligence there and making sure that you know what all compensation is being provided, whether that's cash or in kind, and that you're describing things appropriately in the.
And part of that arises from enforcement actions with the SEC, where some large companies have gotten fined for not disclosing perks. And the way SEC looks at perks, a lot of things fall into that category. And we do have some companies that have done kind of an audit on their perk disclosures, and it's interesting what you can find out there that's happening that maybe the comp team doesn't know about. So it does require a lot of communication with the right people in the company who kind of know what's going on with the executives and what type of benefits they're getting, because you can't just look at last year's proxy statement and roll it forward. Because things change over time, and you do want to get it right, because there are some pretty hefty fines if you don't.
Another topic, this is important to the institutional investor and shareholder perspective, is rigor of performance goals in your incentive plans. That's an area that can be a quick way to get some scrutiny from ISS if you are setting your performance targets for your current year annual bonus, for example, below the actual performance for last year's performance annual bonus. If that's the case, you really need to have a story about why it's appropriate to have a target set at that level. So really about disclosure, they will jump all over that if it's not clearly explained.
Yeah, that's something we always do when reviewing the CDNA for clients is, we compare it to last year and look where the goals are, and certainly we flag that for people. If your goals are below actual performance for last year, I mean, it can be completely justified based on a number of different factors, but you got to make sure you're really forthright with why, because ISS is going to come asking as well, so you got to get it out there.
Another topic that's been controversial at some points has had the impact of stock repurchases when you have earnings per share based goals. Obviously, if you go out and buy back a bunch of stock, that can make it easier for an EPS target to be hit. So investors are well attuned to that issue. Can be addressed by budgeting your goals based on your assumed level of share repurchases, and then making adjustments to factor out the effect of share repurchases above what was anticipated for the year. But if you've got an earnings per share based goal, you're going to need to address somehow how share repurchases affect the payout of your incentive-based comp awards. I do want to reserve a little bit of time for questions here. Maybe I'll just skip to the last bullet point on here. And this kind of comes from the Schadenfreude file here, perhaps. The SEC recently issued some guidance with respect to proxy advisory firms like Institutional Shareholder Services and Glass Lewis, organizations that provide advice to institutional investors about how to vote their shares and in the companies in which they invest, including on executive compensation issues. And for years, many companies have been saying, look, we're not sure how they got to the answers they're getting to. We sometimes think they're getting the facts wrong. We sometimes wonder whether they are applying their policies consistently to everyone, and concerns along those lines. And isn't there a conflict of interest here in some ways? I mean, I think just to beat up on ISS a little bit here, they have this role of advising shareholders on how to vote their shares in public companies, and they also sometimes, even though it may be through a separate arm of the company, will consult with companies on how to meet the standards that they set. Right, so people have been complaining to the SEC for a while now that this is something that needs a little more scrutiny, and we're finally getting some developments on that front. The SEC just issued some interpretations, kind of putting the ISS and Glass Lewis's of the world on notice that, one, their advice to shareholders is a proxy solicitation for purposes of the anti-fraud rules of the proxy disclosure rules. So they need to be, getting the material facts right and not misstating material facts, and also sort of telling investment advisors, it may not be enough just to rely on the fact that ISS or Glass Lewis told you that it was a good idea to vote for or against a particular issue, and that the investment advisors have a due diligence obligation to, even when they're using a proxy advisory firm, to make sure that appropriate procedures are being followed when they are determining how to cast their votes.
Okay, we will begin a Q&A session in just a minute. If you would like CLE or HRCI credit,